What do you do when your dream house becomes a nightmare? Whether you are a new home buyer or paid for renovations, the fact pattern is almost always the same. The building or contractor is super accommodating and nice on the front end and becomes difficult and even abusive at the end. We have seen home construction with collapsing roofs, sagging walls, crumbling foundations, you name it. Invariably, the home builder disappears once paid, and our clients are left holding the bag. The experience for them is miserable and absolutely emotionally upsetting. What are your legal rights in this situation, and what should you do? Well, welcome to the much needed How to Sue Your Home Builder Bootcamp by the Mastercraft Law Firm. This is Charles Master speaking. So you can put my comments in perspective. I've been a lawyer for over 35 years. I'm the founder of the Mastercraft Law Firm and have represented clients with claims against home builders and contractors in Texas for decades. As I do in these telecasts, I will distill everything you need to know about going after your home builder to the three corners of a simple triangle. The apex of the triangle is the Residential Construction Liability Act. It's a rather obscure law, and almost all homeowners have never heard of it, and some lawyers too, unfortunately. You must understand how it operates, or you will lose your rights. The second angle is called claim assessment and looks at whether you have a valid claim to pursue. The final angle in our triangle is filing a lawsuit, which discusses whether that is a good option for you. Well, let's start at the top of the triangle with the Residential Construction Liability Act, which is also known as the RCLA. What it does is set forth a back and forth communication which a homeowner must follow rigorously to preserve his or her claim. Failure to follow these procedures can be fatal to recovering damages against a rogue or deficient builder in fixing the problems which have arisen. The RCLA requires that the homeowner provides a detailed description of the construction defects to the builder or contractor 60 days before filing a lawsuit. Once received by certified mail, the builder or contractor has 35 days to request an inspection of the property. Within 45 days of receipt of the initial notice from the homeowner, the builder may make a written offer of settlement. The homeowner then has 24 days to accept or reject the offer. If rejected, the builder has 10 days to make a supplemental offer. If this offer is deemed reasonable and rejected by the homeowner, there could be a limitation on damages if a lawsuit is filed. Critically, the failure to follow these steps, which are quite complex, will prevent the homeowner from filing a lawsuit, which will be dismissed or abated for non-compliance, and it will also severely limit your damages to be recovered. Bottom line, all of this is treacherous, and you need to follow the procedures. We highly recommend that you consult with an experienced construction lawyer. Keep in mind that if the homeowner provides notice and the builder fails to comply with the statute, and we see this a lot, the builder will lose all protection under the RCLA and allow the recovery of damages which would otherwise be limited or excluded under state law. This will really help the homeowner, and it happens a lot. The next angle in our triangle relates to claims assessment. This is critical, as not all damages for building defects are recoverable under the RCLA. The inquiry relates to whether a legitimate construction defect or breach of contract is involved, or whether the problems are minor in scope and nature. A minor issue would relate to items which go more to subjective appearance, such as whether the painting was done correctly in a specific room on certain walls, or texturizing, etc. Recoverable defects are typically larger in scope and relate to improperly installed windows where the elements come in, doors that don't open, uneven floors, scratched cabinetry, problems with the physical construction of the rooms and the roof, and generally problems that are more systemic than appearance related. It is also critical to determine whether the damages can be recovered under the RCLA, which limits recovery to the cost of repairs, the cost of replacement if repairs cannot be done effectively. And these are rare, but it's a case where the construction is so bad you have to tear the darn thing down and start all over again, and that is recoverable. And also, reasonable expenses of temporary housing during the repair period, the reduction of the fair market value of the property because of the defect. If you want to list it and get rid of it, it's not going to be worth as much. We can almost find some way to cover our client's damages under the RCLA. However, in many of these cases, the builder fails to comply with the RCLA procedures and thus waives all protections. That's good news for y'all. If that happens, all bets are off, and our clients can recover whatever can be proven without limitation. That's good news. And again, it happens frequently. If the builder or contractor abandons the job, they just leave because they don't care. The RCLA doesn't even apply, and you could do whatever you want. The final angle relates to filing a lawsuit. An experienced attorney will always try to resolve the construction problems during the initial 60 days, which is the purpose of the RCLA. It can be useful in resolving disputes. If that is not possible, which often happens with rogue builders and contractors who frankly are unethical, could care less about you, a lawsuit unfortunately is your only option. Having already traversed the process from the initial homeowner notice to the expiration of the 60 days under the RCLA, your lawyer will know whether you have a good case and a lawsuit is warranted. Unfortunately, in my experience, many builders will string the homeowner along, hoping they will back off or give up because of the complexity or expense of the procedures. Oftentimes, it takes a lawsuit for builders and contractors to realize that an aggrieved homeowner is not going to go away. They're serious, and their problem must be addressed. Follow these three angles of the triangle, and you will vastly increase your chance of being successful when confronted by a rogue builder or contractor. Although this is a focused area of the law, an experienced construction law attorney can serve as your best advocate to resolve builder disputes and defects. At Mastercraft, we're extensively involved in representing homeowners and their claims against deficient builders and contractors. We have 8 offices to serve you, and our initial review and meeting is always free. Just give us a call so we can help. This is Charles Monster, wishing you prosperity in all things. Thanks for joining me.